Edition of Polite Society News. My name is Paul Lathrop. I'm the founder of the Polite Society podcast, and joining me today, we have, again, as I did last time we did the show, Alex Ooley of the Forge of Freedom podcast. Alex is also an attorney in Southern Indiana. Alex, thanks for coming along today, man.
Great to be with you, Paul. It's been a little over a month now since we were last together on the air, and it feels good to be back in the saddle.
Absolutely. That was kind of my goal, was about once a month to do this. Everybody knows I put Polite Society on hiatus a while back. About once a month, my intention is I want to do either a Polite Society or a Polite Society News. And there's been enough happening in the legal arena that I thought it might be better just to do a Polite Society News this time around. I want to lead off, Alex, with our leadoff story. When Heller came about, I've said since shortly after Heller happened, Heller gives you the right, no matter where you live in the United States, you have the right to carry inside your house. You have the right to carry, depending on the state, depending on your locality, you can carry on your property. But you can everywhere carry inside your house. Now, no matter where you live in the United States, you cannot carry in a post office. There was a court case that came up recently that may be changing. Can I go to the post office and carry my firearm right now, Alex?
No, not lawfully anyway. Of course, you certainly could, and I think that I agree with the judge here from the district court in Florida that the ban on the possession of a firearm on post office property is unconstitutional. But what's interesting about this case, as opposed to a lot of the other cases that we've discussed and that have been circulating around the various federal circuit, district and circuit courts, is that this was a criminal case. And here a postal worker was charged with violation of the federal statute, which is a criminal penalty. And it's 18 U.S.C. 930A. That's 18 United States Code, Section 930, subsection A, which says that whoever knowingly possesses or causes to be present a firearm or other dangerous weapon in a federal facility other than a federal court facility or attempts to do so shall be fined under this title or imprisoned not more than 1 year or both. And that includes postal offices. And their parking lots, by the way. There have been various cases through the federal courts that have interpreted this statute broadly to include parking lots. So the defendant in this case was charged criminally. He filed a motion to dismiss, and the judge here granted his motion to dismiss the charge against him and only him. So it's not a broadly applicable injunction like we've been talking about with other cases that would apply, at least in the district court where the opinion was issued, or in some cases nationwide, as with the pistol stabilizing brace case. So this case is only applicable to the defendant, and in fact, the post office issued a statement saying that their policy regarding firearms on postal property is still in effect. Now, what's interesting about this is I don't think that the federal prosecutor in this district where this opinion was issued could, in good faith, file a charge against somebody for violation of this. But nevertheless, this does not affect anybody really, practically, other than the defendant.
Okay. This is one where I would love to see. I mean, we eventually got, from the Obama administration, we got national park carry. I would love to see this go into somewhere where through some fashion where we are allowed to carry inside the post office. Look, the post offices are notoriously soft targets because if you cannot carry in there, nobody carries in there. Makes it more dangerous for the entire all of the people there. I don't know about you, Alex. I don't see a whole lot of motion for that in the near future.
Yeah, one thing that's interesting about this case is that it touches on more broadly a category of cases that have been circulating in the courts about so-called sensitive places. And the question is whether a place like a post office or other federal buildings are going to fall within this sensitive place category, such that the government would be able to prohibit someone from exercising their individual God-given right in that place. And I think clearly that by prohibiting uh, federal buildings, just generally, that's unconstitutional, and I think will fail the Bruin standard. Uh, so it'll be interesting to see where this goes. I think that obviously the cases out of California, and I'm blanking on the name of the sensitive place case in California at the moment. We talked about it in December, but that case, challenged the California law that was a Bruin response bill that basically declared every place in the state of California a sensitive place. Anywhere where somebody who was a vulnerable person would go or might go was essentially considered a sensitive place and off limits for somebody's right to keep and bear arms. So I think a case like that will go to the Supreme Court. I think ultimately a case like this one could go to the Supreme Court. Probably not this one specifically, but one like it could go to the Supreme Court and strike down a lot of these sensitive place bans. Now, what's interesting, and I've heard Mark Smith from the Four Boxes Diner make this point, is that historically, as we know, where there's a government law or regulation that implicates the Second Amendment, it shifts the burden to the government to demonstrate that the text, history, and tradition of the Second Amendment supports the prohibition. And they have to do that by analogical reasoning. They have to find a historical analog that is sufficiently similar to the proposed current regulation to justify that it be upheld and found to be constitutional. What'll be interesting is how the Supreme Court, ultimately carves out that analogical reasoning. How specific or how broad are they going to say that analog has to be? Because they've said there doesn't not have to be a historical twin at the time of the founding. There just has to be one that is relevantly and distinctly similar. So anyway, back to my point about Mark Smith with respect to the sensitive places. He says at the time of the founding, the only places off limits were legislative assemblies, polling places, and courthouses. And so if you look at the history of the Second Amendment and the prohibition on the carry of firearms in so-called sensitive places, those are the only three historical analogs. And so really, if the court takes a strict view of the analogical analysis, only those three types of places would be able to be off limits under the sensitive places doctrine. But if they take a more broad view, it's a place like a legislative assembly. It's a place like a polling place. It's a place like a courthouse. Then there may be additional places that are considered constitutionally prohibited as sensitive places. So it'll be interesting to see where they carve that out, and we could get an idea about that through Rahimi.
Yeah, and I've got a comment that just came in I want to get to, but that's where I was going to go next. Spartan 6. Oops, for some reason I don't have. It's not set up right so that it. Let me fix this really fast. And there we go. Hit that one and send it again. And now we go, if the cases are ultimately taken to the Supreme Court and won there, won't the states that want more gun control just ignore the Supreme Court rulings and keep on making unconstitutional laws? They are never punished. And he followed up with, what can be done to fix this? Great question. And when Bruin came down from the Supreme Court, that is exactly what happened. New Jersey, New York, California, and a lot of other places, Maryland comes to mind, made laws that they thought towed right up to the line, but went way over it. Does the Supreme Court have in its I want to say purview, does it have a way to punish states?
I think ultimately, and this is a deeper philosophical question to some degree, ultimately our rights cannot be protected by 9 people in black robes in Washington, D.C. And the Constitution is the supreme law of the land. And if the states are not going to recognize and uphold the Constitution, I think ultimately, and this is getting to the ultimate question, there's going to have to be a populace that's willing to exercise their rights in spite of state government edicts and state tyrannical action. So I think that the ultimate power lies in the hands of the people, not the court. And so that's the ultimate question. Now, I can't tell people as a lawyer to break the law, but what I'm saying is the supreme law is the Constitution, and so that's where I, as an attorney, my duty, my obligation is to uphold and protect the Constitution, and I think that's the obligation of the various legislative assemblies and the courts at the federal level and the state level. So if they won't do that, ultimately the power is in the hands of the people.
All right, let's go ahead and let's move on to our next story here. Victory in Pennsylvania, and this is one that Second Amendment Foundation has been fighting ever since these things started cropping up. This is off a headline off of AmmoLand. Court rules that banning those under 21 from carrying a firearm is unconstitutional. This comes out of Pennsylvania, the Third Circuit Court of Appeals. And apparently now, if you are 18 to 21 in Pennsylvania, you can open carry just like you can if you're 20. If you're 18 to 20, you can open carry just like if you are 21 or older.
Yeah, which is, I think, consistent with the Constitution and the intention of the founding documents, right? I mean, the Second Amendment says that a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So the question is, who is part of the people? And I think clearly the history and tradition of the Second Amendment includes 18 to 20-year-olds. I mean, let's face it, these are folks who can serve in the military and fight on behalf of the United States here and abroad. These are people who we allow to do all sorts of other things that are part of adult life. But we want to say that they can't exercise one of the most fundamental individual liberties that anyone can have, and that is the right to self-defense, and by extension, the right to keep and bear arms. So I think this decision is in accordance not only with Bruin and the test established, or not established really, but recognized by Bruin and made clear by Bruin, but also consistent with the intention of the founders of the Constitution and the Bill of Rights. And one thing here, I heard this, I can't remember, I heard this recently, but I like it. We call the first 10 amendments to the Constitution the Bill of Rights, but it doesn't give us rights. There are a few positive rights that it gives people in there, like the right to a jury, but primarily the Bill of Rights is a bill of prohibitions on the federal government. It's saying, government, you cannot do these things. You cannot infringe on the right to free speech, the right to keep and bear arms, the right to be free from unreasonable search and seizure. It is a bill of prohibitions on the government. So I think that helps frame really what the purpose of the Bill of Rights was. It was to restrain the government, not to give people rights.
Yeah, I'm right there with you. I want to take a little bit of a turn here. When the Constitution was adopted, yeah, it's the Bill of Rights, but as it was originally interpreted, it was the prohibition on the restraining of rights was only on the federal government. The federal government could not infringe on your right to free speech, your right to keep and bear arms, your right to a fair and speedy trial, and others. The states weren't necessarily bound by that, and it has come almost, I'm going to say, of the Bill of Rights, the first 10 amendments, all of them apply to the states. That's my understanding. Is that right?
Yeah, so it's not all of the Bill of Rights yet. The beginning after the Civil War, during Reconstruction, the 14th Amendment was passed, and the 14th Amendment was meant to address problems with ways states were treating newly freed slaves. And the intention was that the 14th Amendment would uh, provide due process and equal protection to everyone, including people who were subject to state edicts, not just federal government uh, misconduct. So, through a process of what's called selective incorporation, the courts over the years since the Civil War have incorporated selectively, piecemeal, that is, parts of the Bill of Rights. And for instance, the Second Amendment was not incorporated, that is, to apply to the states or to restrain state government action from violating the right to keep and bear arms until 2010 with the McDonald decision. So, 2008, Heller decided in the Heller decision, the Supreme Court said that the Second Amendment is not some collective right. It protects an individual right to keep and bear arms in the home. But Washington, D.C., Heller was decided in Washington, D.C., which is a federal enclave. So it didn't involve state government action, it involved federal government action. And then in 2010, the Supreme Court decided the McDonald case, which was a case out of the city of Chicago, Illinois. And in that case, the Supreme Court said that yes, not only does the Second Amendment protect an individual right to keep and bear arms and protect that individual right from federal government action, it also protects people from state government action, and they thereby selectively incorporated the Second Amendment to apply not only to federal government action, but to state government action. So
All right.
today, going back to your question, most of the Bill of Rights has been incorporated to apply to the states, but not all of it.
All right. And the I would imagine what is contentious. The Second Amendment obviously has been, as you mentioned in the Heller decision or the McDonald decision, but I would imagine that a lot of what normally comes up in the legal arena is what has been, for example, the First Amendment, the Fifth Amendment, that has been applied to the states. Maybe not necessarily the Third Amendment that they cannot house troops in your home.
Yeah, yeah. And for instance, in the Fourth Amendment, that's one that comes up a lot as well. Uh, the Eighth Amendment, to be free from excessive, cruel and unusual punishment, excessive punishment, things like that. So, um, yeah, there are most of, and I can't tell you exactly off the top of my head which ones have not been incorporated, but most of them have been incorporated. Now, one thing I'd like to go back, if it's okay with you, Paul, to
Sure.
the first case we talked about, because I think this is relevant not just to the post office case. Uh, I think it's applicable or an issue that we've seen come up in various cases around the country. They said in the post office case in the federal district court in Florida, one of the issues or arguments that came up was some dicta from Heller. And dicta, remember, is language in an opinion that's not essential to the holding. So it's just basically explanatory language. It's not essential to the holding of the case. And in Heller, there was some language, some dicta in the opinion that said that the decision is not intended to cast doubt on the constitutionality of laws prohibiting firearms in government buildings. Well, that wasn't what the court was deciding. So the court was only deciding whether or not the right to keep and bear arms was an individual right, and whether or not the federal government, by prohibiting Dick Heller from possessing a firearm in his home, an operable firearm in his home, was a violation of the Second Amendment. And so this language about government buildings was just dicta. It wasn't essential to the holding in in Heller because it didn't involve a government building. But
Right.
nevertheless, these anti-gun attorneys, anti-gun groups are latching on to some of this dicta in Heller and in Bruin to uphold or to say that these prohibitions should be upheld and that they're constitutional. Constitutional. So those are just some tactics that they're using to try to uphold these uh, violations of the Constitution, essentially.
Absolutely. I do want to move on to our next story. This one caught my eye. Excuse me. Caught my eye from Ammoland. The headline: Civil Liberties Group asks Supreme Court to rule against ATF's unilateral bump stock ban. And when I do my news searches, I get a lot of stories with titles like that. And I thought, well, let's see if it's SAF, if it's excuse me, if it's maybe Brandon Combs down with uh, got it. My brain is frozen. Uh,
Whether it's one of the usual
yeah,
suspects, right, in the fight for the right to keep and
exactly.
bear arms. Yeah,
Firearms Policy Coalition is what I was trying to
right.
say. Or maybe the GOA, or even NRA is starting to get a little
Yeah.
more active again now that Wayne is leaving. But this group is the New Civil Liberties Alliance. From what I've been able to research, a very small group, but they've weighed in on Garland versus Cargill, the bump stock ban. Um, I'm wondering, Alex, if somebody's out there and they're passionate about Second Amendment rights, if they're passionate about what's going on and want to become more involved, is it prudent to start your own little group, or should you maybe go and align with one of the pre-established groups? What's your thoughts on that, man?
Yeah, well, I think there's a place for both. Obviously, it depends on your ability, your resources, your the time that you have. But I think some combination of both can be effective. Obviously, the Second Amendment Foundation, Firearms Policy Coalition, and Gun Owners of America, those three in particular, have been very effective, especially post Bruin, but even prior to Bruin. I mean, the Second Amendment Foundation has been at it for many decades now. Uh, and I think those are great groups that people should consider supporting. But for instance, I'll just give an example. Here in Indiana, an advocate and an attorney from Indianapolis, he has a radio show. His name is Guy Relford. He has a radio show called The Gun Guy. He started his own group, a state-based group called the 2A Project. And at least starting out, one of the primary purposes or goals of that group was to get constitutional carry or permitless carry adopted in Indiana. And basically, his impetus for or his reasoning for starting that group was that the NRA, he was trying to pick up the ball where the NRA wasn't able to maybe get the support that we needed here. And I think it was very effective, particularly at the state level. Now, is somebody going to start a grassroots organization that's effective nationally? Probably not, at least not initially or for several years. But I think that if you see a space in your state or even at the local level where an advocacy group might be effective, and that may just be advocating to local politicians, to county council, to city council, to local commissioners, to prosecutors, sheriffs, etc. I think that small groups can be very effective and may grow. So, to answer your question, I think that if you have the time and resources to start a group, especially at the local level, I think that's where change starts to happen and can be most effective for you and your loved ones.
Well, and I will say, do not underestimate the amount of time it takes to run one of these organizations. One thing that I have found very common throughout my dealings with gun rights organizations, the successful ones, the leaders, really have no life outside that organization. Nobody that I have ever met in my life works harder than Alan Gottlieb does. I would put Brandon Combs of the Firearms Policy Coalition in a very similar light, uh, as well as Eric Pratt with Gun Owners of America. I never met Wayne LaPierre. I do not know anything about the man other than what I picked up in news. But those three organizations and those three people are extremely hardworking, and they're at it balls to the walls from the minute they're up in the morning until they go to bed at night. They are working constantly, and I would just encourage somebody, if you're looking at doing a organization and you're going to go past hyper local, if you're going to go past your own neighborhood, you need to have oodles of time, and you need to have even more drive than you have time.
Yeah, yeah, I agree with that wholeheartedly. And just to sort of echo your points about SAF and FPC and GOA, uh, again, they're wonderful organizations, but even they have very limited resources, and they have to prioritize the cases that they pursue and the initiatives that they push. So they're not always going to get to the issue that may be most important to you. Uh, Indiana, for instance, is a relatively gun-friendly state, but it's not, for the most part, going to be high on the radar for SAF, GOA, or FPC because they have a lot bigger fish to fry, a lot more urgent concerns to take care of. So if you're in a state like Indiana and you want to still promote and improve the status of the Second Amendment and the right to keep and bear arms in Indiana, for instance, you may want to start a group to push
Sure.
for those issues that FPC, SAF, and GOA just can't get to because there are more important pressing issues elsewhere.
All right, let me get a. I'm going to take a left turn here, and I want to get another comment from Spartan 6 up. He says, "Does anyone else think that eventually all the socialists, liberals will label all groups who oppose them as subversive and move to suppress them by all means necessary?" And he follows up as in with the January 6th / Reichstag fire model. You know, that that's something I hadn't thought about before I seen the question pop up. But yeah, I honestly think that if you don't go lockstep in line with the ultra liberal, they're gonna they're gonna target you in whatever way they can. If that is labeling you as a subversive, that's what they're gonna do. Especially in the political environment we're in right now. What do you think, Alex?
Yeah, I agree. And this is a tactic that's been used throughout history to demonize people who don't share your agenda, and typically to share your agenda with respect to state power and to the centralization of power for your purposes. And you see that for reasons not just gun related, but I think lots of people criticize looking back to the Nazi uh, Socialist Party in Germany during and before World War II, but I think it serves as a great example of the sorts of tactics that you see happening today. Now, there's a huge difference in a matter of degree, but it's the same sorts of tactics. And as a matter of fact, I visited a concentration camp, Dachau, a little bit ago, and I was reading through some of the historical materials there, and they would label people asocial, for instance, and that was initially a reason to uh, take people into concentration camps, not just because of their religion or their race or their gender or their sexuality, but because they exhibited asocial tendencies. And well, what does that mean? Okay, and so you see that today that people are subversives or they're asocials or they don't fit our agenda in some way, and so we need to lock them up or in some way suppress them, and so I think that is a concern. But once again, this goes back to a question earlier in the episode or in the show that we're not going to be saved by non-black robes in Washington D.C. We have to have a people that's willing, able, courageous enough, brave enough to stand up to these sorts of tactics and these sorts of measures.
Absolutely, and this reminds me. I seen on social media a post here a while back where they were asking, "Is it is it time? Is it time to go?" And where is that demarcation line? And there was one answer to that that was really, I think, hit it on the mark. And the person said, "Look, there's plenty of groceries in the stores. There's still, even in the worst states, there's still some freedom for now. Uh, the general life of the American citizen is not that bad. It's not time now. It may never get to be time. Talking about an armed uprising, and I'm right there. I've never been in war myself. I've heard enough descriptions. I know enough people that have been in a real war that I know that unless there's no other choice, I don't want to take part in one. And I think it's put upon us to do everything we can outside of that to make changes before it gets to that.
Yeah, agreed. I think all but the very few and most crazy people want some violent solution. Most people want a peaceful resolution and want to keep their freedom without any kind of revolution or uprising. And and I'm like you, Paul. I don't think we're there yet. I don't think it's soon. Of course, you never know how the tides can change or how quickly, but I don't think we're there yet.
No, and
And if we can find peaceful ways to maintain our freedom, we should do that.
I'm going to tie this in a little bit. And we had one more story I don't think I'm going to get to, but I'm going to tie this in a little bit to what's happening at the southern border. Thank goodness, in more than half of the country right now, we do have a real right to keep and bear arms because we effectively have no southern border. And there's a lot of people coming up here. Not all of them have the greatest intentions. Um, I think it's incredibly important for us all right now to exercise our Second Amendment rights to stop those that may be coming up with bad intentions and bypassing all security. I think we need to be the fallback for the federal government.
Yeah, yeah. I mean, let's face it. We are our own first responder, and whether that's violent people who are coming across the border, and of course that's not all of them, or even most of them. That's very few, but it is a significant number. Or just people in your own hometown, gangs, whether it's drug related or some other violence. You are your own first responder, and I think that's true today, has always been true, and will probably be continue to be true uh, for as long as humans exist on this earth. So that's something that we need to take as seriously today as we ever have. That's for sure.
All right. Well, we are past the 30 minutes that I usually like to try to keep these at, so I'm gonna work on shutting it down. Alex, thanks for joining us today again, man. I love talking with you. I love that I learn everything every time I do.
Likewise, it was great to be with you, Paul. I always enjoy our conversation and look forward to coming back again sometime soon.
All right, folks, we are going to wrap it up here. We've still got comments coming in. Thank you, everybody who's commented. Thank you, everybody who's been watching. I plan on, as I said at the beginning of the show, I plan on doing this about once a month. That's what my current job kind of allows me as time to do this. It'll either be a Polite Society or a Polite Society news, but about once a month I'll be coming out. We'll talk about what's been going on and what the path is going forward. Thank you, everybody, for watching. Podcast listeners, thank you for listening, and we will see you next time.